Hello. Good morning, everybody. Am I audible?
Good morning, sir.
Good morning.
Yes,
Yeah.
you're audible.
Audible, please. Yeah.
Yes. Good morning,
Hello.
respected sir,
Good morning,
dear
everybody.
participants and member
Am I
of
audible?
center. Yes, you're audible.
Yeah. Good morning.
Should we begin?
Good morning, sir. Yeah. Good morning.
Yes,
Yeah.
you're audible.
Audible, please. Yeah.
Yes.
Good morning, respected sir, dear participants and member of center. Yes, please.
Before starting, I would like to request everyone to please keep their video and microphones off so that it will be better for the better connectivity. So, shall we begin? Okay. Good morning, respected sir, dear participants and member of Center for Research on Criminal Justice. I, Madhura, on behalf of CRCJ, will be coordinating today's session. I welcome you all to the third session of Criminal Justice Talk, which was introduced to encourage the discussion between research, policy, and practice, and further to contribute to wider public debate. Following this objective, we have today with us Advocate Ganesh Sovani sir, who is a criminal lawyer and senior panel counsel of Union of India. He will today present his ideas on law relating to police encounter. Now I request sir to please take the session ahead from here. Over to you, Ganesh Sovani sir.
Sir, can you unmute yourself?
I
Sir, can
have.
you unmute yourself?
Yes, I have. Am I audible now?
Yes, you are audible, sir.
Fine. Fine. Thank you. Yeah. Okay. Where is the camera?
Yes, sir, right there. You can begin.
Yeah. Good morning to everybody. Yeah. Now today's topic is police encounter, pertaining to encounter, police encounter. And the caption which we have given, I'm getting delayed sound, delayed echo I'm getting.
Sir, for us it is working fine. You can begin.
Hello. Where is the screen? I can't see myself. Yeah, fine. Yeah. Now see, today's topic is law relating to police encounter. The topic which we have named, it's I should say it is mischievously named in the sense that the topic law relating to police encounter should always pose a question to a reader or your participants that can there be any law regarding the police encounter? How can there be a law? How can there be an enactment to that effect? You are having CRPC, you are having Evidence Act, you are having in IPC also. So many Makoka is there. Many criminal laws are there. Minor criminal laws are there. So can there be whether Indian Parliament has ever passed any law which can be called as a police encounter law? No, it's not the case. It's not such. The point which one should immediately come across, or one should always ponder, that what are the laws which could possibly governing if any police encounter takes place. Now, police, as you know, department falls under Home Ministry, which is carved out essentially for the maintenance of law and order. Their job is to preserve law and order hour into 7 into 365 days. That is their prime duty. Now, question arises, if that is the case, then why the encounter takes place? When this phenomena of encounter has started, responsible for it, whether any individuals are responsible for it or the system is responsible for it, or entire political environment and socio-economic environment in our country is responsible for this. Now, as you are aware, for last 7 months or so, now we have almost crossed July. Today is the second last day of July. And just in December, 8 months back, entire country was absolutely devastated with the news that one female veterinary doctor, she was returning to home from her dispensary or hospital, whatever it is. And in the process, she was obstructed by 4 unruly men, I should say, criminals. And they took her away. They committed a serial rape. So it was a gang rape incident. And on the top of that, they murdered her. Now, when she was being chased, she was on a scooter. She happened to have telephoned her brother, who in turn attempted to have informed the control room that such and such my sister is being chased by someone. Please send some police personnel, etc., etc. Instead of listening to his grievance and addressing his grievance, unfortunately, the police gave him a very rude answer that she doesn't know that what time to return and all that. With such a alone she should come back and all that. They started giving pep talk to him rather than addressing his query or grievance, I should say, or the request of police support or enforcement or whatever. As a result of which, the lady was absolutely left in wilderness. She was all alone. She was gang raped. She was murdered. Her body was mutilated, thrown, etc., etc., and which had created an uproar throughout our country. Huge uproar, entire country, irrespective of the local language. It was in Gujarat, it was in Assam, it was in Kashmir, it was in other southern parts of India, it was in central parts of India. All the channels and newspapers, they were just blasting the Telangana police, the manner in which this female veterinary doctor was not given an aid, police aid, as a result of which she was required to lose her life, precious life. On the top of that, her dignity was outraged. She was raped and murdered. And that created a whole question mark on the efficacy as well as the efficiency of the police department over there. Now, after a huge media pressure, this made an international news also. I personally watched it on some foreign channels. And that created a sort of an atmosphere on the Telangana police that they have no option but to catch the culprits first, which they did successfully after a couple of hours or so. After some initial remand, they were put in the judicial custody. Now, the incident of her abduction, incident of molesting her or committing a rape on her, and then murdering on her and causing disappearance of her body. Everything had taken place after the sunset. You can imagine after sunset, what is the position of natural light all around. And if on this background, on one particular morning at wee hours at 3 a.m. or so, the concerned police, without obtaining any formal permission from the concerned magistrate in whose jurisdiction she was, because she is on the judicial custody. Once the accused is in the judicial custody, it is the magistrate who is having control over that particular accused, whether male accused or female accused for that matter. So without obtaining any formal permission of that concerned magistrate, these 4 accused who were successfully caught, they were taken out of the prison And under the pretext of recreating that incident, restructuring that incident, they took him out at 3 a.m. Now imagine the natural light in the evening when the incident had happened, and imagine a natural light at 3 a.m. in the morning. They don't match or tally at all. Instead of 7 p.m. when the incident took place, if they would have been taken a couple of hours later, even at 9 p.m., one could have understood it because it was night. But at the wee hours in the morning, they were taken under the pretext of restructuring the scene. And under the pretext that they tried to overpower the police party, police personnel, they tried to snatch whatever the weapons or arms which they were carrying. And to stop that happening, these 4 culprits were encountered. That is the theory which came out by the Hyderabad Telangana police or Hyderabad police, we should say. And then immediately press conference was taken, and everybody in the country felt a sigh of relief that accused were finally eliminated. And within a couple of days after the happening of this incident, the accused were no more on the earth. Entire universe, they are gone. So we felt many of us felt very happy. Many of us, more so female fraternity, for the obvious reasons, they said that right punishment was meted out to these culprits. That's fine from your perspective. The question is this: whether their lives were snatched away by the Telangana or Hyderabad police as per the provisions of law, because Article 21 of the Constitution of India, it gives complete assurance to everybody that your life and liberty cannot be taken away by anybody except the person is contemplated under the law. Now, as you are aware, even during in this pandemic, only the 2015 incident, Delhi gang rape incident, that particular victims, culprits were ultimately hanged. They were hanged after a gap of almost 4.5 years plus. But they were hanged as per the procedure which is duly established by law. No doubt it took delays, they went on making one appeal after another, presidential representation and all that, etc. So that caused a severe lapse of time. But ultimately they were hanged till death as per the death warrant issued by the final court of appeal, which was the Supreme Court. And Honorable President also rejected their mercy pleas. Now here it was an incident of Hyderabad where they were no doubt eliminated. One can say that had they been tried in the same way in which the Nirbhaya matter was tried, even they would have been awarded a death sentence and they would have been ultimately hanged. But that would have taken place a couple of years' time, 4 to 5 years or so, even if the matter would have gone to the fast track court and all that, because there is a first appellate court is there, High Court, second appellate court, Supreme Court, then presidential reference is also there. They can approach for the mercy, so on and so forth. So there was a huge joy, there was a lot of exhilaration. People were happy that they were sent to death. But those who are having faith in the democracy, those who believe certain provisions of law we have to abide, and they ought to have been abided by the police machinery. That is the state. It is the duty of the state to promulgate law and implement the law. And in spite of this, if such persons are eliminated under some false pretext, it is a matter of great concern. There is one judgment which I am going to cite a little later. That is called administrative liquidation. The encounters in another parlance is also called as administrative liquidation. Now, with that one particular encounter, the entire debate on this murder of that Hyderabad veterinary doctor, it came to an end. Just 3 weeks back, we had another sensational encounter, and that was of Vikas Dubey, which everyone are aware of. That he was a gang lord, he was a big gunda in UP. On the second and intervening night of 2nd and 3rd July, when the police party was going to arrest him, it was coming in big number on his house. He ventured to kill as many as 8 police officers, he and his associates. It included also DYSP. And then he ran away from the place near Kanpur, Chaubepur, that precise area or locality, Chaubepur police station in Kanpur. He ran away. Where was he? Nobody knows. Some people say that he was seen in Faridabad, he was seen somewhere in other parts of northern India, etc. But finally, he surfaced at Ujjain Mahakaleshwar temple. He was seen in the temple. He was seen mentoring into temple. He was passing through many CCTV cameras and so forth. And when one security guard, private security guard, happened to have identified him, and then he was taken into custody, the local police, Ujjain police, were reported. He was formally arrested. UP police were informed, and after informing UP police, they came to catch hold of him, and finally, the UP police decided to take him to Uttar Pradesh, where he was supposed to be taken. However, in the midway, that too again wee hours, under the garb of he attempted to overpower the police party. One version is that he attempted to overpower the police party and he wanted to run away from the vehicle. There was a scuffle and in the process he was killed in the encounter. Another version is that that entire police party that was going with so many vehicles nearby, police vehicles which were followed by the media also, at certain section the media was halted. Initially he was taken through one Tata vehicle. Finally it transpired that the vehicle turned turtle. It turned out to be a Mahindra make vehicle or something. One vehicle A was there, but the one which turtle in which he was supposedly trying to flee away after killing attempting to cause injuries to the police party, that was another kind of vehicle. And ultimately it transpired that that was the only vehicle it turned turtle. And the whole controversy arose whether it was a genuine encounter. Nobody believed the version that was advanced by the UP police. And that created a huge question, as a result of which Supreme Court, Chief Justice of Supreme Court, Honorable Chief Justice Sharad Bobde decided that this is a fit case for the appointment of some inquiry, and therefore formal Supreme Court Honorable Justice B.S. Chauhan and another UP DG rank officers, they have been appointed as a part of the committee and they are supposed to finish the inquiry within 3 weeks' time, and then they will submit a report and the further action will follow. Question arises is this: whether any policeman who is having a weapon with himself while discharging part of his duties is entitled to terminate the life of any person without the procedure that is established by the law. The answer is absolutely not. He has no power at all. Now, you being the student of the law, you must be aware that our criminal system, police, they are the one who are supposed to take the cognizance, they were supposed to lodge an FIR, who was supposed to set the criminal justice system in motion by lodging an FIR, what we call as a CR number, under the appropriate provisions of the law, act, sections, etc., etc. Investigation is entrusted to an investigation officer. That is the prerogative of the senior of the police station. And the officer IO, once he steps into the matter, he goes to the scene of offense. He collects whatever the remnants that are left over there, interrogate the people, and subsequently the charge sheet is filed. Then when the charge sheet is filed, that is called police report under section 173 of the CRPC, that is also called Challan in the northern India. Then the prosecutor, on behalf of the police, he presents his case. Charges are framed, matter goes on trial, complainant on oath states, his witnesses also state, who are cross-examined by the defense counsel, and subsequently the honorable court, trial court passes a verdict. It could be a magistrate court or it could be a sessions court if the matter is avowing a punishment of 10 years plus, which is a session tribal matter. And if the matter involving murder or dacoity with murder, in that case, now amended provision of rape cum murder, the session judge is empowered to pass a verdict of death hanging till death. So this entire process is called criminal justice system. In the police is one component, prosecution is another component, defense of the accused, defense counsel is another component. This is all the criminal justice system is consisting of. Now, how can you in democracy bypass this criminal justice system and straight away kill someone under whatever pretext that he was trying to attack you and all that, or he was trying to run away and all that? If at all Vikas Dubey, after the vehicle was turning turtle, wanted to run away, assuming, then the police could have stopped him by hitting on his legs or below his waist so that his legs would have been impaired and he could not have flee. So simple it was. But that didn't happen. The question is this, whether the police, who are the part of the state, are entitled to terminate anybody's life without due process of law. The answer is absolutely no. Then the question arises, what is it that power derived by the police, by virtue of exercising it, they can liquidate any human being? Answer is very simple. In CRPC, there are the provisions in Chapter 3. Self-defense is a right which has been duly acknowledged under the CRPC. The sections run from section 96 onwards, and it is the section 100 that is very paramount discussion. Now, police often say they take a plea or they take a defense because their life was threatened by the criminal. So they had no option but to use arms which were at their disposal. It could be a rifle, it could be a pistol, or it could be a revolver or 3003, whatever it is. So whatever the weapon which was at their disposal, they decided to exercise that weapon. And had they not exercised it, then their life would have been in danger and they themselves could have been killed by that miscreant. So therefore, they establish or they exercise their right of, and therefore they eliminated or they liquidated that particular criminal life. That is the defense that is normally taken by the police fraternity whoever are embroiled in any encounter controversy. I'll be citing certain examples over here today. Now remember that the person from whom the threat is caused is either he could be in their custody, just like the Vikas Dubey was. Mind well, in Vikas Dubey's matter, he was traced or he surfaced in some another state, that is Madhya Pradesh, and he was being taken to his original state of Uttar Pradesh. Now, any prudent, any lawyer who has just completed law practice will be wondering why his transit remand was not taken. No doubt the traveling time could be less than 24 hours. A police can detain anybody for a period of 23 hours, 59 minutes to be very technically. They can detain without any warrant from the court, without any orders of the court magistrate. Assuming that traveling time from Ujjain to Kanpur was not at all of 24 hours, it was less than 24 hours. Still being a different state, still he's a man who was absconding and whose surface or is traced or arrest in another state. It was the bounden duty of the police party. Appropriate instruction ought to have been given that this transit remand should be taken. Initially, the name of one Trupti Pandey magistrate was came into surface that it will be produced, she will be produced before him, and then under her orders he will be taken. But that didn't happen. There was a coup-by, obviously. So the police have to take transit remand if the accused is in their custody from one state to another, or even I would say from one district to another. But that didn't happen. So either such person is in their custody, or just like what we see in the movies, all of a sudden the police come across that villain. Villain challenges the police, and there are exchange of fire, and in the process, police kill that particular villain, and that is how he is eliminated. Gunda is sent to the heaven. This is what the police say, and the hero says, "Usko bhej diya upar." Now, mind well that the person has to be in the police custody. If he is in police custody, then it is the duty of the police to preserve in the fit condition till the trial concludes. I mean, nothing should happen to him. He's in the safe custody, in the remand custody, it is in the police station, and then subsequently he's in the judicial custody, which is a magistrate custody. Then the prison administration is supposed to look after him, his well-being, everything as per the jail manuals is provided, everything, food, clothing, shelter, etc., etc. Now, as I said, the right of self-defense is police. I'm going to cite one example which has happened in Mumbai. In 2009, one incident had happened. In that incident, one person who was having business enmity when A was having business enmity with B, B decided that he should avail his good acquaintances in the police department, and so that he can settle the score with of A rather. And it did happen that the B conspired with his known police officers in the crime department, and the person and his friend, they were abducted from Vashi. They were abducted from Vashi. They were put in Toyota car, Innova, and then by Toyota car they came to near Bhandup. In Bhandup, his friend was put into another car. So the person who was supposed to be liquidated was in one car, Toyota Innova, and his accomplice, his friend, both of them had gone to Vashi for some business purpose discussion and all that. His friend was put in another car. They were taken to Warsaw police station at Andheri. And in Warsaw, there is a place called Nananani Park. So at that Nananani Park, the police made a stay. The Pradeep Suryavanshi was the in charge of that particular police station. Physically, they were taken over there, and subsequently the story was made out or cooked up that they were just looking after some criminals. They were searching some criminals, and at Nananani Park, they came across this particular deceased or the victim of the encounter, and they asked him to surrender. He did not respect to their command or orders, I should say, and he attempted to exchange fire with the police, and therefore police had no option but to liquidate him or conduct an encounter of him. And that made his brother to file a writ petition in Bombay High Court demanding that offense of clear-cut murder under section 302 of IPC should be registered against the in charge of the police station, and that particular in charge, along with his police party, they were around dozen in number, who had gone along with the men in charge of the police station. They ought to be arraigned as an accused. Initially, their names had not surfaced, but after revealing their identities, they were subsequently added as accused. So the Bombay High Court upheld that particular writ petition, and a direction was given to lodge an offence, and offence was lodged. Matter was investigated. Charge sheet was also sent in that matter, and some of the accused happened to have applied for the bail, and that bail came to be rejected. Matter went to the High Court also. Again, some order was passed which was challenged by the one of the accused called Prakash Kadam, and the matter went to the Supreme Court. The matter was heard by Justice Markandeya Katsu and Justice Gyansudha Mishra, who had passed an excellent order, and they have said, I must read it over. That cancellation of bail. Accused police officers and staff engage in private party to kill their opponents. Accused police officers and staff function as a contract killers. During the investigation, it was found that accused police officers and staff abducted the deceased and killed him in the fake encounter, merely because some members of the police party were duty of guarding the deceased. It cannot be said that they were not party to the conspiracy. If the police officers and staff could kill a person at the behest of the third person because it was a supari killing, it cannot be ruled out they may kill important for their relatives or give threats to them at any time of the trial of a case to save themselves. Now, in this particular matter, though the matter before the Supreme Court was merely pertaining to the cancellation of the bail, because some of the accused, the bail was granted by the Sessions Court, that order was challenged in the High Court. The High Court reversed that order, bail stood cancelled, and that cancellation of bail was challenged in the Supreme Court. The trial is still pending, but though the trial was in the process, Honorable Justice Karju went to the extent of saying the act of police in this matter was so deplorable. The Justice Karju had made an observation, which I must read it over here, that policeman must be given death sentence, treating it as a rarest of rare cases. If the offence is committed by the policeman, much harsher punishment should be given to them, because they do an act of totally contrary to the duties. Their duty is to preserve the law and order. Here, on the other hand, they're taking supari on behalf of someone and just eliminating obviously nobody will do this act for a free of charge. Some booty is always going to be exchanged in this. And the court warns policemen, that means Supreme Court has warned the policemen that they will not be excused for committing murder in the name of encounter on the pretext that they were carrying out their orders of their superiors, officers, politicians, howsoever high. So this is a landmark judgment in which Justice Karju and Justice Gansudha Mishra in the para number 26 has also, they have also opined. Gauri Rane, our coordinator, will give the precise citation. She will upload it. It's from AIR 2011 Supreme Court, page number 1945, in which Justice Karju and Justice Gansudha Mishra, they have also opined that police should refuse to carry out the orders of their seniors if the orders are patently false, they are illegal, incorrect, and not as per the provisions of law. This is the absolute order passed by the Honorable Justice Karjo and Gansudha Mishra, that lower rank police officers, they can very well, their refusal to obey an illegal order or more than one illegal orders, if the same are not as per the provisions of the law, they can very well refuse. And if the illegal orders are being given to them, obviously they will have to report to their superiors who are giving illegal orders. If the PSI is given an illegal order by PI, then it will be the bounden duty of the PSI that he should report it to ACP or DCP in that police hierarchy. That my immediate superior is giving me orders which are patently illegal and which I am not supposed to abide by at any cost. So this is one particular example of Warsaw killing. It's a very famous case and the matter is still pending in the Honorable Bombay High Court. Well, I'll give one more example. This is a matter of 2013 settled by the Supreme Court. Ultimate judgment was given. And the matter arises out of a series of encounters that were taking place in the state of Manipur. Though it is a very small state, it is surrounded to foreign countries, foreign borders are there. A lot of infiltration also takes place at many times. A lot of insurgency is also there. And many foreign nationals, they do intrude over here. And some local miscreants who are in tandem with the foreign mercenaries, they do commit some kind of activities which can be dubbed as an anti-national activity, called as a treason also sedition, so on and so forth. So these are essentially the terrorists who are getting carried away by the lot of provocation that is getting from across the border. Now in 2010, 2011, 2012, there were a lot of insurgencies taking place in Manipur, as a result of which the people from Indian Army, now remember our policemen, what we see here in cities and towns, though they are police, they are called civil police. They are from us. Whereas army falls under defense establishment. Our police falls under the home department, where the army, navy, air force, ITBP and other, whatever the CRPF and all that, BSF and all that, they fall under the military establishment, defense establishment, except I will say saving or exception that border security force falls under the home department. They are not directly coming under the military or defense department. So when the Manipur intruders were carrying a lot of anti-India activities, they were killing local peoples and all that. But it did happen that military personnel, they did cause to disappear some local persons who were no way concerned with the anti-India activities. And they have nothing to do with any kind of killing or any crime for that matter, which could be fallen. But two such innocent persons were picked up, though their relatives or friends could be involved in anti-India and some other activities, including murder and all that. So two personnel were liquidated by the military establishment, army people, and that made an extrajudicial execution victims families association. One NGO came forward, which filed a public interest, which filed a writ petition under section 30 of our Constitution of India, in which again, Justice Aftab Alam and Ranjana, they say they passed an order in which it has been said that fail encounters custodial deaths, the fact that the state is infested by the insurgency, or that the lives of many policemen and the members of security forces, including the army, are lost in fight against insurgency, that cannot be the defense for the army or even the police fraternity to liquidate such innocent persons. If at all they have been involved in any crime, let the FIR be registered, let the investigation take place, let there be a trial, there be a first verdict, of even including death, and that the law takes its own course. But you can't just liquidate them merely under the pretext that they are part of the insurgency group and all that. So the process of such kind of liquidation has been deplored by the Honorable Supreme Court. Gauri will upload that verdict. It is 2013, All India Reporter, Supreme Court Weekly. It is 590. It is EVFAM versus Union of India, in which such kind of killing by the army men has been seriously deplored. One more verdict which I will be citing, which has been much in the debate after the Vikas Dubey's encounter took place some 3 weeks back. And this verdict is absolutely important for every policeman in India, be him in Kashmir, be him in Kanyakumari, be him at Dwarka, or be him at Assam. This particular judgment is applicable to all police fraternities, state police, or union territories for that matter. I will first read the caption and then we will start discussing the ratio that is laid down in this verdict. It is 2014 All India Reporter, Supreme Court Weekly. It is 5940. I repeat, 2014 AIR SCW 5940, or its equivalent citation is 2015 Criminal Law Journal 610. Now, this was by the PUCL, People's Union of Civil Liberties versus State of Maharashtra. Now, remember, in Maharashtra also, in mid-90s, the Makoka Act came into effect in mid-90s or latter half of mid-90s, post-1995. Essentially because a lot of gangs were operating in city of Mumbai and around, having allegiance to people who are settled abroad, Dubai, Abu Dhabi, Pakistan, or other places. And there were ABCD gangs. I would not name them. We call it just 4 different gangs. 4 top gang lords were there. And their persons who were operating in around Mumbai, they used to do engage in a lot of extortion, life-threatening activities, murders, assaults, and so on and so forth. And extortion was the prime object. Now, in order to overcome this act of extortion, the government had no option to promulgate a law called MCOC Act. Organized crime was such a rampant that there was no option to the then government to form this MCOC Act. It was promulgated and it is called draconian by those who are affected because of the passing of this act. But otherwise, it is a good act. We do also appear for the many MCOC accused also. The period of police custody is very much compared to normal 14 days custody under the IPC. And there's an extension provision also contemplated in that normal custody is of 90 days. It can be also of 180 days under the application if it is made by learned APP, special prosecutor. Such offences are tried by the special court. Now, in 1990s, lot of encounters had taken place in Mumbai, and lot of police officers, they were glorified as an encounter specialist. I don't want to name them, that is not our topic of discussion. But A became very famous encounter officer, B became very famous encounter officer, C also became, D also became. And fake encounters unfortunately got such a publicity that the officers who were involved in the encounters, they became the heroes of the society. But that was a false world, because there are certain instances which subsequently revealed that the people who were arraigned as an accused in that particular encounter, some of their associates, they were caught, others got killed in the encounter, and when they were put on trial, they got honorably acquitted. The question arises, if the police officer claims a gallantry award or some reward for committing an encounter, causing an encounter, and after the matter was tried, and in the trial the accused got acquitted, then what is the sanctity of that award or the reward? And therefore, this particular judgment, which is delivered in 2014 by Justice, the then Chief Justice R.M. Lodha and Justice R.F. Nariman, Rohington Fali Nariman, who is currently number 4 in the Supreme Court. This particular verdict is nothing but the guidelines that have been issued by the Honorable Supreme Court, and that the guidelines, it has been specifically mentioned that these guidelines has a force which is as equivalent to any law passed in the parliament. Deaths in police encounter, its ratio is investigation. Supreme Court laid down the requirements to be followed as standard procedure for thorough, effective, independent investigation. Said requirement norms are to be strictly followed by treating them as a law declared under Article 141. Remember, Article 141 of Supreme Court of India is so sacrosanct that any passed under it, it has the same force, the force which is otherwise available or which is derived by any legislation which is passed in the parliament, approved by the Honorable President of the India, and which is then gazetted. So this verdict, which are the guidelines, are as if this is passed by the parliament. Now, in these guidelines, the Honorable Supreme Court has listed the procedure which the police party must follow whenever any encounter is likely to take place or which has taken place. If the encounter has taken place, then what they should do with the deceased, what they should do with his dead body, so forth. Now, one passing reference I will have to make over here is that under section 46 of the CRPC, let me tell you very honestly, and with a little apology to my brother advocates, that many of our brother advocates are not aware that by virtue of section 46 of the CRPC, police are empowered, they are allowed to utilize bare minimum force, inverted commas, bare minimum, that is extremely, which is essential if the accused is trying to get away from their custody. He is also using some force if suppose I have nabbed any accused, and if the accused is using some force, he's a robust man, or he's having some danda is there, or he's having some iron rod or something of some object he's having. If he's trying to use that particular object in order to evade the arrest, then under section 46 of the CRPC, police are within their powers to utilize this force. But most of the times what happens, the force is utilized, but the utilization of force, I always tell my police friends that utilization of such force should always reflect in the remand report. For the simple reason that when the accused is produced before the remand, the first question that is asked by the magistrate to the accused, do you have any grievance or the complaint against the police? If he's going to say that yes, there is a complaint, I was beaten up and all that, whether it is a natural beating or some other kind of beating, deliberately made beating, that apart. If police make a station diary entry also, parallel entry in the case diary also, that when we attempted to arrest the particular culprit accused, he tried to evade the arrest, and that is why we were required to use force on him. And when the police party uses a force, that is bound to cause some kind of abrasion, some kinds of minor injuries, some kind of wounds, etc. on his body. So if at all the accused is going to say that yes, I have a grievance against the police and they have beaten up, then in that case, whatever the injuries that are reflected on the person or the body of that accused, they are attributed to the use of the force which police were compelled to utilize it or make or exercise when they attempted to catch hold of that particular accused. Therefore, I have been always advising my police friends, if at all you are using any force for the purpose of arrest of the accused who is trying to evade, then you must mention this, you must create a diary entry, case station diary also, and in the remand report, you should, before accused could make an allegation through his lawyer that police had beat me up or they have caused me an injury, etc., your remand report itself will reveal that in this particular instance, the police were required to use the force, and therefore, whatever the injuries are reflected on his person, that can be or which is the outcome or the result of that particular force. So this is for section 46. Police have to keep in mind, and not just keep it in mind, it should reflect in the remand report so that allegation can be made. That allegation can be made less effective, it can be made blunt by taking a recourse to the incorporation of section 46 using of force in the remand report itself. Now, in this particular guidelines, the Supreme Court has laid down the procedure that is required to be adopted, and I will just read that. 2014 Supreme Court cases 5940-2015 CRLJ 610. Now, in this particular guideline also, what is emphasized is that in the rarest of the rare cases, police party should be required to use the force. And as of now, the encounters has become, the nomenclature encounter has become so dubious that no prudent person will believe it. Now, in defense of their encounter, apart from saying that our life was endangered and citing a particular instance, when the police want to defend their action, they do say that the A who got killed in the encounter which we were forced to carry, much reluctantly, much against our desire and all that, he did threaten us. He had an arm with him. And therefore, we thought that our lives were in danger. To make that threat eliminated, we were required to eliminate. But that can't be the general defense. Even sometimes, as a general defense of fake encounter, many police officers have said, they've come out with a statement that the man who was killed in the encounter, he was so dreaded criminal, having dozens of cases against him of murder, attempt to commit murder, 302, 307, rape, etc., etc., dacoity, robbery, etc., etc. And she was such a gunda, she was such a big dada in that locality or in that town or the city or in that area or the district or taluka or whatever, that if he would have been put on trial, no person who otherwise has been cited as a prosecution witness could have dared to step into the witness box, and he could have given a deposition in consonance with the prosecution theory, in favor of prosecution, in favor of the police department, and by endangering his own lives. I mean, nobody would have dared to depose against that man. And if at all such trial of that particular person who now stands eliminated after the encounter, it would have prolonged for years together, adjournments and adjournments. Then even if he would have been convicted, there was appellate court, first appellate court, high court, second appellate court, Supreme Court, so on and so forth. So that would have killed the whole initiation for taking a prosecution against him. And after 10 or 15 years gap, if the Supreme Court is to say that the evidence against him is deficient, this is no case for the conviction of the accused. So earlier conviction granted by the trial court or endorsed by the High Court, that stands set aside. So many police officers I have seen in seminars also or in their write-up also. But that's not a case. I will give one example. Those who are knowing Ulhasnagar or Kalyan area, there was a criminal, a big fellow called Pappu Kalani. And Pappu Kalani was such a big name in that area, Kalyan and Ambernath Taluka, Ulhasnagar, all that. Many businessmen, common man, common person who believes in the law, who abides the law, is just scared by uttering his name, Pappu Kalani ka aadmi. And many people, small timers, criminals, they used to extort the money by saying that hum Pappu Kalani ke aadmi hai karke. But in one particular matter, I do remember, Pappu Kalani was tried in the Kalyan Session Court. He was convicted. Rigorous imprisonment was awarded. That was endorsed by the Honorable High Court when he went in the appeal. That was again challenged by Pappu Kalani in the Supreme Court when two concurrent findings were against him. Natural course took place and the Supreme Court affirmed the conviction that was granted by the local court, the trial court and the High Court. and he's still in jail. It did happen. It could happen only because police seriously followed in this case. Police prosecutor, notwithstanding a lot of pressures that could have been exercised on him, stood firm. He should be also complimented for training all the witnesses. It's not a case normally a prosecutor and a witness when the matter is for the trial, and today it is a trial at 11 o'clock before the sessions court or even in magistrate court. They hardly get a time to get acquainted with each. They hardly get a time to deliberate or discuss on the whatever the FIR has been given by the complainant at the relevant time, or whatever 161 statement that was given by the witness to the investigation officer. So hardly there is any interaction, and just prosecutor says, "Ha bola pude kay zala," then what happened next, then what happened, then what happened. That kind of just getting ahead with the matter starts, and hardly that is a called appropriate training or appropriate tuition of the witness. But in Papu Kulani's matter, that particular police prosecutor needs to be complimented. Entire police team, investigation officer also deserve a lot of appreciation from everybody. And Papu Kulani is still in jail. So this all happened because of the appropriate coordination between the police agency, prosecution, witnesses, the court staff, and everything. When it synchronizes perfectly, it results in a good conviction of the person. So this is how the matter, no matter, I mean, howsoever the big criminal involved, if there is appropriate coordination, synchronization is there, it's not that you should kill every person who could be otherwise not to crack. Now there is one more particular judgment which is very vital, which is used by the police fraternity as a defense whenever a police party which is engaged in an encounter, and if that encounter has been challenged by the relatives of the victim, and that is resulting into the prosecution of the police party which was involved in an encounter, then normally the defense that is available to the police party, apart from self-defense, they also say that this particular prosecution, this particular filing of a criminal case is vitiated because there is no sanction from the government. Now remember, under section 21 of the Indian Penal Code, there is a definition of public servant. Now whenever any public servant is arraigned as an accused in respect of a crime in which he is participating, he is acting upon while discharging a part of his duty, and if such person is arraigned as an accused, FIR gets filed against him. It could be even anti-corruption, prevention of corruption matter also, not just necessarily encounter which is in arms. Accumulation of wealth, bribe, such things are not uncommon in our government departments. So if such person is arraigned as an accused, investigation takes place, charge sheet is filed, then one plea that is used by the defense counsel, because even I have used it some instances, that he was doing all his act while performing or discharging his duties as a public servant, and therefore if such is the case, then under section 197 of CRPC there is a provision that no court can take cognizance of such a crime. Cognizance is taken of a crime. So no court can take a cognizance of a crime if the crime is sanctioned by under 197 of CRPC. Prosecution sanction is not there for the conduct of the trial. Now this one particular judgment which I am going to cite, you are a lawyer, you must know both sides of the law. That this has arisen of an incident which is in Punjab. In 1984, many of you may not be even born, or you lost to me, due respect to you. In 1984, Golden Temple was infested with so many ultras, so many terrorists, that our then Prime Minister Madam Gandhi she had no option but to direct our army to troop into it and eliminate those terrorists who were holed up in that particular sacred place. So in 80s, there was a huge phenomenon of ultras, terrorists and all that. So Tada Act was enacted in 80s and Punjab was declared as a disturbed area. After a passage of time, Tada was replaced by Pota. Then Pota came to be repealed. The Pota were incorporated in UAP, Unlawful Activities Prevention Act, almost identically. Cut and paste provisions have been there. But Pota was repealed. That's not my subject to topic today because it will be another half an hour will be spent unnecessary in that. So Punjab continued to be a disturbed area. Even though Tada was removed, it was replaced by Pota. So one particular person was killed in the encounter by the police, whose family members in the particular district, Taran district of Amritsar, which is adjoining to the Pakistan border, he was arraigned as an accused. And he was having some small crimes against him, but he still was eliminated by the police party by citing that he was a terrorist, he was sympathizer with the terrorists, and he was aiding and abetting terrorists. That was false allegation. So his father, after the encounter, happened to have challenged the particular encounter, and FIR came to be lodged against the police party which was involved in the eliminating that particular man. And the matter went to so much extent that the investigation of that particular matter was by the CBI. Trial started. And when the trial started, the police officer who were in the dock as accused, their lawyer took a defense that this particular prosecution of the Punjab police who are accused for eliminating a particular person, this has no sanction of the government at all under the 197. Now remember, if the act that has taken place is in the Punjab Disturb Act of 1983, it required two kinds of sanctions. If the person who are in the dock, public servant, are the state government employees, then obviously the sanction of the Punjab state government, home department of it, its sanction is also required. And because it was from the disturbed area, had it not been disturbed area, that's a different thing. Because it was in the particular incident in the border area, which is declared as a disturbed area, the sanction of the central government was also required. Not just merely because CBI was the investigation agency, but it was falling in the Taran, which is the border area, disturbed area, and therefore the two kinds of sanctions were required. One of the state government, one by the union government. Those were required for the initiation of the prosecution or the criminal matter or criminal trial for that matter. Now, this particular case law is so important because it says that merely because you are discharging your statutory duties as a public servant, you don't get any special powers, you don't get any special protection, or no special cover is there for you. And therefore, this government says that even if in this particular instance there was only a state government sanction, CBI sanction, CBI was the investigation, no union government department sanction was sought. Objection was raised. Trial court said that even if there is no central government sanction, let the trial start. Then that starting of the trial was objected by the accused. The matter went to the High Court. High Court also said that the act done by the police party is so blatantly illegal. The kind of circumstances, the time, place of offense, scene of offense, they have been narrated. An unarmed man has been killed by the police. It can't be called as it was done by this as a right of exercising self-defense, and therefore this is such a case that the police have exercised the powers which were not vested with them. When your life is to conduct an encounter, there is no question of when there is no aggressor, a person cannot derive the right of self-defense, and therefore trial court said that this is not a case where police deserve any mercy. Let the trial go on. Then the matter went in the Supreme Court. Then the Supreme Court directed that the entire papers be, though CBI was having investigation power, CBI was the investigation agency, the matter got halted for 3 months, and the Supreme Court passed an order that CBI is having a very huge machinery to scrutinize and study. They are having, in fact, I am told that any crime in which the finally charge sheet is laid by the CBI, that entire bundle of charges, I should say, FIR, witness statements, Panchanama, medical reports, so on and so forth, that is scrutinized at 7 different layers, 7 different. And if all the 7 layers agree that yes, this is a fit case for the prosecution, then only the charge sheet is laid, otherwise charge sheet is not laid. So much of care is taken to ensure that the investigation is done properly. Excuse me. Sorry, I beg of your pardon. So the conviction rate of the CBI related matter is so high because it has been scrutinized at 7 different stages, 7 different layers, and therefore the CBI is always regarded as a most successful investigation agency, and therefore the people are scared. People are afraid of when the matter is investigated by the CBI because there is little chance of getting it thoroughly probed. So in this particular matter, the Supreme Court said that let the CBI, it's all these legal officers and all that, they examine the entire file. Until that time, let the trial goes on. If it comes to the conclusion that yes, there is an element for which the sanction is needed, then only that matter can, then point can come up. Otherwise, there is no bar in the stoppage of trial. And in such case, the Supreme Court has said that court will examine the question of sanction from evidence that is adduced by the prosecution or accused that there were reasonable nexus of incident with the discharge of official duties. So much of so, this citation I will read and then I will tell you the crux of this matter. It is AIR 2016, Supreme Court 2090, AIR 2016, Supreme Court 2090. Equivalent citation AIR 2016, Supreme Court Criminal 758. It says that, in nutshell, it says that let the trial can go on right up to not just 313. Mind well, that 313 is the stage which comes in the trial court, criminal trial court, be it magistrate court or sessions court. When the entire prosecution evidence is over, all the witnesses of the prosecution are over, complainant, witnesses, panchas, doctors, experts, so on and so forth. When the prosecution closes, whatever the evidence that is gathered by the trial judge is accumulated, and the trial judge in turn puts the so many questions 1, 2, 3, 4 to the accused. That look, this is the evidence against you on this particular point. This is another evidence running against you on such a point. So all that evidence that is gathered against the accused is read over to him, and he's asked his explanation. And in normal course, all that you say that I don't know, it is false. There is a uniform answer is given. But at a fag end of that particular 313, the honorable judge, trial judge, asked the accused why all these prosecution witnesses are talking about you. Why they have deposed against you? What could be the reason for that? At that particular stage, it is the lawyers or defense counsel, whoever represents accused. I always say to my client, if at all he is accused, 313 evidence is led to him, even in the Negotiable Instrument Act, which is just like a civil dispute actually, but it is conducted as a trial. It's just arising out of some monetary things. So that is the last question. Last but one question. The accused has ample of opportunities to put up his case. And mind well that 313 deposition is not under the oath. So their accused can lead whatever he wants to say about this matter, complainant, whatever the transaction is there between the two. And finally, last question, why he says so? Then why is it that you have to answer? And last question, then he said that this is a false prosecution against me. That is the last answer given by the accused. Then the trial court, trial judge asked the accused, do, and there the accused has every opportunity to lead his evidence, but mind well, the evidence is always laid by taking an oath. As I said, for 313, no oath is required. But accused wants to lead an evidence, then he will have to be in the witness box. No doubt 313 statement is recorded when he is in the witness box. If he wants to lead the evidence, he will have to take an oath, and then he will have to lead the evidence. Mind well. Earlier, sorry, just question and answer session. Sometimes it does happen that accused without leading the evidence, that means he's not stepping into witness box again on oath, but he can bring some witnesses who can depose in his support as defense witnesses, accused witnesses. Just like the prosecution witnesses, there are accused witnesses are there. So without getting himself involved as a person who is deposing on oath, the accused, instead of that, he will ask B, C, and D, etc. to depose on oath in support of his, especially alibi is the case that when a particular person is, he brings an evidence that on that particular day at particular time I was not physically present there at all. So to substantiate this defense or the contention of alibi, he can bring some evidence of his innocence. So this particular judgment of Supreme Court says that let the trial go on, let the prosecution lead his evidence. Even if this evidence is over, 313 statement is over, accused is requesting that I should be permitted to lead evidence or to justify my action if the self-defense is the plea in that case. So Supreme Court has said that the trial should not be halted or it should not stop merely because central government sanction was not there, only it was the Punjab government sanction was there. So the accused can bring this sanctioning aspect even by examining the witnesses in support of them or him, either one accused, one him, or multiple, more than one accused, them. Then at the time of argument, after the evidence has been closed from both the sides, then even also accused can raise the plea that this prosecution is void ab initio for such a reason that it did not have a central government sanction, and therefore it has vitiated the trial, and therefore on this ground only I should be discharged or we should be discharged if there are more accused than one accused. So this is the fourth judgment which I have cited. Now remember, encounter is such a delicate area where it has always two sides. Police are having one version, the victim's side is also having another version, and mind well, most of these encounters, if you have observed, they take place at a very isolated place, desolate place you can say, when nobody is around. Some ground is there, field is there, background of some godown is there, field or near riverside, on highways when nobody is there. So the location wise it's a desolate place. One has hardly heard or seen any encounter which has taken during the daytime. 99% encounters take place at night time. So there is no moments of the other persons around who could be the potential witnesses against the police who conduct that encounter. So the place and time are very two critical things. Now, when police claim that we were required to fire as a matter of self-defense, then the burden is on them to show that a man to whom we have killed, he was an aggressor. He was an aggressor. He threatened our life. And I know some instances, very funny instances, that is how the encounters always come under the doubt. Remember that if A is a police officer, B has threatened him, A is exercising right of self-defense, and A is going to kill B when he's supposed to be in front of him. A's life will be endangered only when B and A are face to face. And in that case, when A uses his pistol or revolver or whatever the arms which he is having, on the round that will go through the body of the B, the entry point of that particular bullet or round that will cause a hole in the chest will be having some diameter. Obviously, it comes at such a fast speed, instantaneous, that bullet comes out from the back. I have seen 2 encounters I have come across when the entry point of the bullet from the chest is supposed to have some diameter. Exit point, it takes out the skin from the backside. So the diameter of the exit wound is always greater than the entry point diameter. And if that happens, then that is the right case when one can be tempted to believe that it was a genuine encounter, because entry point diameter is always less. That takes skin inside the person's chest, and exit, the skin goes out of behind the back. So outside the diameter is more, inside the diameter is less. We know 2 instances we have come across where the diameter of the backside of his back was a smaller and the diameter of the chest was a larger. Suffice to say, that gave a credence to the belief that the officer had shoot the victim when his victim's back was facing the police officer. If somebody's back is facing the police officer, how that can endanger the life of the police officer? It can't, unless the victim is going to take his revolver across the police officer in this fashion. That is not going to. And therefore, this is a very delicate area. The police should not indulge in any kind of encounter activity when it is really natural, course in course, and really it is a genuine. Otherwise, it backfires. It creates a prosecution on the police party itself. It derives a very bad name to the police department. Entire government comes into trouble. Media highlights the deficiencies or the intricacies of such kind of encounters, and that kicks off a lot of theories, and that shows a very bad sign of governance. And therefore, this is such an area where one has to be very cautious. Causing a face encounter might give us some kind of publicity or 2 or some rewards, as I said. But of this 2014 case law of Justice Loda, which I cited, it has specifically laid one ratio that no gallantry awards or rewards should be given to of the encounter party unless it is resulting into the conviction, or rather I should put it away, unless it is resulting into the acquittal of those persons. Also remember that when the encounter takes place, normally the police party lodges an FIR by invoking section 307 against the deceased. They say that deceased attempted to kill us. So attempt to kill is covered under section 307 of the IPC. So they file an FIR against a man who is already dead, who will not be available for the deposition. So against the dead person invoked, and prosecution takes place. However, one particular judgment, as I said, arising out of Andhra Pradesh in 1997, that whenever encounter takes place, it should be the raiding party which should be made as an accused, and not that victim, which is the normal procedure for the last 2 decades or so that was taking place all over the country, that the deceased man who has been killed by the police is made an accused under section 307, when they know fully well he can never come up, he can never be alive to depose that how he was innocently killed. So this is a remarkable departure of the Supreme Court, which has now strictly laid down that no gallantry award, nothing of no decorous officer of a raiding party should take place till they come out clean. Otherwise, if the accused party, suppose that the victim is having some other accomplices with him and they are put on trial, and then that case, what will happen if they stand honorably acquitted? The people who were accompanying the deceased, who were accompanying the victim, and he only came to be encountered. So this particular judgment of Justice Loda and Justice Nariman says that for no reason they should be decorated till they come out clean. There's a very landmark ruling which is in force, but unfortunately which is not appreciated by the police department. As a result of which, the encounters like what we saw in Telangana or what we saw in Vikas Dubey matter, they do take place, and that brings a very bad name to the department. This is all what I can say in today's particular session or the webinar on police encounter. There is no such codified law. All that defense that is derived or taken by the police by invoking section 96 to 100, which are available for the self-defense by the police. So it is only section 100 of the IPC which comes to the rescue of the police personnel. Under Article 21 of the Constitution of India, nobody has any right to take the life of anyone except the procedure which is duly established by the law. This is how sum and substance of the police encounters, which I can say. Any of one who are having any queries, you are most welcome to address your queries. That's all.
Thank you so much, sir. It was a very informative session. Now we shall proceed towards the question that participants have posed for you.
Yeah. Now, how do I see? Can I see those queries? Is it possible?
I will read them for you.
Okay, fine. My pleasure.
Okay. Is it the case that in alleged encounter, the burden of proof always lies with the police?
Obviously, because they are taking a defense, they are taking a plea of self-defense. So they have to justify their action of causing an encounter.
The next question is, with respect to Telangana rape case and Vikas Dubey, can it be said that magistrate failed to give directions to police to protect the life of accused and ensure that they live to face trial?
No. Coming back to this Hyderabad Telangana case, after exhausting police custody remand number of days, maximum it could be 14. Then the accused go to the judicial custody, what is called JC or the MC. It is called judicial custody. It is also called magisterial custody. MC or JC, one and the same. In Mumbai city, it's called JC. Outside Mumbai, it is called MC. Then the accused, once they are in JC or MC, they come under the prison administration. Now, prison administration, they are having their own set of rules. They are having own rules about the administration, about the inmates. Many of them are under trials. Some of them are convicts, but they stay in the same place. Same camps or same wards, whatever you can say. But they wear different kind of clothing to get identified. Convicts wear different thing. Under trials, they wear different clothes, apparels, I can say. Now, when they are under the jail administration, only when they are to be brought to the court for the purpose of trial dates. It is the police party which go to pick them up under the authority of the trial judge, under his endorsement. And they are taken from the prison, they are presented. Once the court business transaction is over, then they are brought and then again deposited back in the jail. So, as I said, that when they were taken out for reconstruction of the event, where was the sanction of the magistrate? There is nothing on record to suggest that Telangana police, a previous day or even before they were taken out, they could have woken up the magistrate at midnight and said that at 3 p.m. we are required to take him out for the reconstruction. But that didn't happen. So when the accused under trials are inside the jails, police have virtually no control over them. Any other question?
Yes, we have one more question. Is it the time to reintroduce the jury system at all level of judiciary, beginning from trial court up to the apex court?
No, 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 no. Last incident of jury in India is the KM Nanavati case in Mumbai. That is the last instance where the jury was there. The jury are the persons from the public. They are the one who are made to sit to watch the proceeding. They were now not they are because it is the thing in the past. So entire court proceeding is also seen by them. And then judge used to ask, what is the opinion of the jury? How they perceive this case as a common man. Lawyers are there, they are having extra additional knowledge. But how a common man who is a part of it will read this case from their perspective. So jury opinion used to prevail once upon the time, but this came Nanavati case, the jury thing is gone now. So no purpose will be served by introducing because the law has gone such an enormous change. Remember, though evolution of law has taken place at a great deal, there has been no necessity or no need was felt to amend IPC drastically. Remember the foresight of the Britishers who had laid down this IPC in 1870. Our former CRPC was of 1873. And the Evidence Act is also of 1970s. 70s, 100 years plus. Almost 150-year-old enactments. So the evolution of law has taken place very big way. But at this juncture, there is nothing which wants the reintroduction of the jury. That is what I can say.
Okay, now we will take the last question.
Okay.
Is it possible that a police officer in a rank of police constable can disobey the order given by his senior office of the department? While doing such act, he or she might loses their service, I guess. As far as my knowledge goes on, in our country, police officers are the most privileged people. It is quite difficult to disobey an order made by them.
Yeah, I fully agree with your. In fact, there is no question in whether you only have a point about the things. That it is very unlikely that the constable will not be obeying his superior's order. And should he disobey so, whether that order is legal or illegal, that apart, there will be a reporting of that particular constable to the super to the DYSP. Then that constable will have to face departmental inquiry. And in the departmental inquiry, if it is found that the constable was not justified in disobeying the order of his senior, then he will be held accountable and he will be punished for his non-obedience of the superior's order. So unless it is so patently illegal, no police personnel of whatever rank will dare to disobey the order. If it is patently legal, no senior inspector will say go and kill that fellow. That will not going to happen. But unless it is so patently illegal, nothing can happen. Nobody will venture to disobey. So who will lose his service? That will have effect on the family also. So there are such instances where the lot of corruption takes place because of the obedience of though partly on the face of it they may appear to be legal, but if you go into deep, it could be an illegal.
That was today's last question.
Yeah.
So I would like to wind up the session. Thank you so much, sir. It was a very informative session. I,
My pleasure.
Madhura, on behalf of Center for Research in Criminal Justice of Maharashtra National Law University, Mumbai, and everyone present here, would like to extend thank you to Advocate Ganesh Sovani, sir. Sir, it was really very informative session. I also thank to all the participants for being a patient listener. In the chat box, we are providing a feedback form. Please do fill the feedback form before leaving. Thank you so much for joining with us.
Thank you. My pleasure too.